Yes, Doctor. Dr. Nasiru. There are some things that I want you to make clear to me. The XBKCD1, the appointment letter, it says that there are further conditions of your employment as stated in the attached. Please take time to read it, sign and return the signed copy to the Personnel and Human Resources Department. Those conditions are not produced before the court bar. It may, aside from the employment letter, there are also other conditions in regulating the employment.
There are no, usually there are industry-wide conditions which are not particularly relevant for our purpose.
Yes, but I know, but the employment letter says some conditions are attached, and the employee should be able to should go through them, read them well, and sign them. I expected that those conditions should have been before the court, so that if there is any thing with regards to payment of salary containing those conditions, the court may be guided by those conditions. But from the look of the documents presented by the claimant, those conditions have not been produced before the court, isn't it?
Yes, because we, like I mentioned, my lord, those conditions, they are usually sent by mail. They are not peculiar to this nature of employment. They are more or less industry-wide conditions.
Okay. Okay. Then another question is,
can we get this for the conditions? Can we get it?
yes, Doctor, another question is, you are, excuse me. It's because I don't want to go and write my judgment, deliver my judgment before giving you a fair hearing. Your first relief is you are claiming for the sum of 237 USD, 207,000 United States dollars. Right? And in the course of the proceedings in your pleading and evidence, you said the actual amount was 190 something thousand USD and 40,000 USD as interest. As interest.
That was the earlier statement, the earlier statement of facts. We have an amended statement of facts dated the 29th of April, 2022.
What does it say?
That one only talks about, there are 6 reliefs there. The first one talks about the sum of 237,315.68 being
Yes.
differential in salary.
Yes.
And what he is entitled to at the prevailing exchange rate of Naira to dollar from 2010 till April 28, 2019. That's the first in the amended statement of facts. The second one is the sum of 28,113.66.
No, no, that one is your commission. The second one is your commission, ba?
Yes, the second one is the commission.
I'm not having any issue with the issue of commission because there are documents, evidencing that the contract, the letter, the agreement between the claimant and the defendant about the 5% commission. I don't have any issue with that. You have been called CW2 and he tendered documents showing that the contracts were awarded to the defendant and payments were made. I don't have any issue with the only issue I have with the commission is to declare that the claimant is entitled to present and future commission, because in respect of the future commissions, there isn't any document presented before the court that the payment were made to the defendant. So there's no way I can say that he'll be entitled to a future commission, because as in the other cases, in the previous commissions, it was shown that payments were made to the defendant.
That's correct. Yes, ma'am.
And in the agreement, it was agreed that the commission is payable when payment is made to the defendant.
That's
so with regard to the commission, I have a question on the order for declaration that the claimant will be entitled to a future commission because it's premature. It's premature. You have not yet presented any document that the defendant was paid. So with the commission, I don't have any problem. But with regards to the issue of salary, the $237,000 in the email, that is exhibit
differential.
Exhibit 12 is the email. Even in exhibit, sorry.
Can I say something, my lord, about this declaration that we are seeking?
Yes, what do you want to say?
What I want to say is that, the way the payments are made, they can raise an invoice and then payments are not made until subsequently. So we still have some invoices that are raised, but payments are just being made after this period. But we cannot put a figure to that.
No, what I'm saying is that are those payments evidence of payment? Are they before? They are not before the court.
I agree. They are not before the court.
Yes. They are not before the court. So since they are not before the court, there's no way I can make a declaration that somebody be entitled to a future commission.
I agree, man. It's okay, man. It's okay, man.
Then because the contract respect of the payment of the commission says the commission will be payable on receipt of the funds from the client.
Yes, that's correct. Yes.
So I'm coming back to the salary. Even the claimant in the email correspondence, that's exhibit KCD 12. KCD 12. I think this is KCD 12 A to E. So number A, B, C. He says
the claimant demanded a current exchange rate.
Yes, I'm trying to refer you to the paragraph the claimant sent a letter to Mr. J. He said, "Hello, J." That is the last, the second to the last paragraph.
Yes, my lord. Yes.
And the last paragraph of exhibit KCD 12C.
Yes,
he said, my unpaid salary amount as at August 2018 is 182,737 USD. Unpaid salary in bracket, unpaid salary is 155,000, and interest over the years is 27,000 USD.
Yes, my lord.
So my question is that, how is there any agreement that the non-payment of salary will attract interest?
Well, what is, we believe that in the ordinary nature of commerce and withholding somebody's money,
yes,
because the value of that money at that point in time is
yes,
different from the time it's going to be paid.
Yes, but the thing
because
is that
it's a matter of contract.
You
can't say.
Is there any agreement expressly saying in the event of failure to pay salary, that failure will attract interest?
No, our contention is that it is implied when you withhold money from someone, even
Yes.
if it is salary, you are withholding money, and the person is entitled to have that difference. And the only difference that the difference will come is by way of interest on it, because we are not asking for damages.
Okay, even in the absence of any express agreement, you can still assume that interest will attract, the money will attract interest.
That is our contention.
That that interest will accrue in the event of failure to pay salary.
Yes, my lord. Because if you deprive the person of the money, the only way you can assuage.
It means the 200 okay, this is in 2018. This is in 2018. And in 2019, when you wrote a demand letter to the defendant, in the solicitor's letter dated 11th of March 2019, this is what you also say, that this is what the letter says. From the calculation of our client, the differential between what you paid as salary and actual sums due between 2013 and February 2019 is $107,000. Interest on this sum at $40,000. And it means that the sum due to our client as differential is $237,000. That's the differential.
Yes,
the actual amount is $107,000, and the interest accrued is $40,000. So I still have a question on how you arrive at the interest. You know, what parameters? What parameters do you apply to arrive at that interest?
We were looking.
Even if there is an agreement, express agreement saying that in the event of failure of payment of salary, the salary will attract interest. That agreement has to still say how much interest, how much, still 5%, 10%, or we'll just give, leave it at large at the discretion of the claimant to say this is what I think is my interest.
My lord, my own understanding is that,
yes,
I agree that this is a master-servant relationship.
Yes.
This is a contract upon which there is a definite amount as salary.
Yes.
You withhold that money from the person, the employee.
Yes.
You did not pay as
how was it withheld? How was the money?
The extent that there was a differential, you were supposed to pay so much.
But doctor, even in the statement of account that you tendered, there's no place in the statement of account showing that this is what the claimant was paid as his salary. This is what, he was not paid as his salary. In the system, the system of account, the system of account is from, look at it very well. It is from
account.
Yes,
the statement of account that we said,
yes,
that we show the differential.
Yes.
Let me have the statement of account that shows the differential. Okay, the statement of account shows amount paid and then the difference, and then we have the interest on the other column.
Where is that shown in the statement of account? Where is that shown?
The interest is shown in the last column.
It's saying balance. Balance.
Yes. We have the year, the amount paid, the correct equivalent, the difference, and also the interest as the last column.
No, from the face of the explique CD, that is statement of account. What I can see is entry date, value date, description. That's so.
No, what I have is the one that has the 197,069 as salary differential, interest of 40,000, and then total payments. I don't know whether that is the one that.
No, I'm speaking about the bank statement of account.
Okay, the bank.
Yes, not the computation made by the claimants.
As the call, please.
Bank statement of account, because the doctor, those computations made by the claimants, they are his own computation.
Drawn from the accounts.
Which account? How did you arrive at the computations? Because I have the statement of account here. It is from 31st of January 2006 to 23 of December 2010.
Yes.
That's what the statement of, that is the area, the period that the statement of account covers. From 2006 to 2010. 2010. And we are claiming for salary, that's differential. is from 2010 to 2019.
Yes, my lord.
So the statement of account you brought is from 2006 to 2010. While your claim for non-payment of salary or differential is from 2010 to 2019. So my question is that how does the statement of account that covers the period between 2006 and 2010 prove non-payment of salary claim between 2010 to 2019?
My lord,
Yes.
Even the correspondence that we have,
Yes.
It shows that
email. That is the emails, isn't it?
The emails that we have, there's an email that is dated. My lord?
They are the correspondence. The emails are the correspondence.
That's right, the correspondence.
Yes,
it shows that
I think they are only correspondence made between the claimant and the defendant in respect of the payment of and non-payment of salary.
They are on the they are both on the salary and also the the commission.
Yes. Yes. What do you want to say? What do you want to say?
One of them is September 21, 2018 that talks about says he has not been paid all his salary and they continue to keep 51% of my salary against my
who is saying that? Who is saying that?
That is the claimant.
But the defendant also said in the correspondence that let me refer you to the place that they said they have paid the claimant salary. Look at exhibit KCD 12D, the last paragraph.
Yes.
It says, I think it was sent on the 21st of September 2018. It says, "Hi, Kenneth. You have been paid all your salary to date. There's none outstanding. And as 1st January 2018, commission is no longer been paid throughout the group. You have been advised of this. There is a profit share available, and I will shortly forward to you a year data analysis of Nigeria's profitability based on global sales. Kind regards, J. Horton, Vice President Finance." This is the statement sent to the claimant by the Vice President Finance of the defendant that he has been paid all his salaries. He has been paid all his salaries.
Because this was a contention which they made.
This is the contention made by the defendant that they have paid the claimant his salary. So what I want to have from the claimant is how did the claimant arrive at the computations made? Because there are about there's exhibit 15, which is set on paid salary from March 2019 to date, which is 276,000. You didn't even claim that one. You didn't even claim that one in your relief. That is from 2019 to date. You do not claim that one. You do not claim that one in your reliefs. In your reliefs, you didn't claim the salary between 2019 to date. There's no specific. So the computation you made, that's exhibit KCD8 again. KCD8, which is exhibit KCD8. That's the salary differential. It was computed by the claimant. At the end of it, you said total salary differential $197 US, interest $40,000, total payment $237 USD. So what I want is that, how did the claimant arrive at this computation? How did he arrive? How did he arrive? Is there any, okay, for instance, the appointment letter says that the claimant's salary was 30,000 USD. It was reviewed to for 2,000 USD.
Yes, that's correct. Yes.
Then the claimant was saying that the defendant started paying me in dollars, but at one point stopped, and was paying partly in dollars and partly in naira. Where is that evidence? Where is that evidence in your pleading? You didn't state through what? Through which means that the claimant is being paid his salary. I mean the dollars and the naira. Is it through bank? The bank or hand payment? If it is through, the bank, is there the bank statement of account showing this is what I've been paid this month? This is what I'm supposed to be paid. This is the difference. If he's been, if it is a table payment, is there any document showing that yes, I've been paid this so amount, and I have acknowledged, being paid the receipt of, so amount? There is none.
The way to go around this, the statement of account,
yes,
shows the inflow of the salaries.
Yes, but doctor, the statement in which currency? Is it in naira or in dollars?
We have the naira component that was paid into.
I mean the bank statement of account.
Yes, it's in naira.
In naira, yes. How did you, and the bank statement of account is from 2006 to 2010.
Yes, that was the time. That was the period that he started paying in dollars and in naira.
Yeah,
then at that time the conversion was done.
But your claim for the differential is from 2010 to 2019 in your relief.
That is correct, because we didn't have any issue at that point in time.
Yeah, okay, you didn't have an issue between 2006 2010. Is that so?
No issue at all.
That's why
when the default started was from that period, and that's the mail that my lord just read.
Then when the default started, you did not bring the statement of account in respect of the from the time that the default started. From the time that when there was no defaults between 2006 and 2010, you brought the statement of account. But when the default started, there isn't that statement of account that will show that there was a default, that will show that this is the difference.
From the correspondence between the parties, the contention has always been that there is default in using a current CBN rate.
Yes, but the defendant denied it, said that all the claimant's salary, has been paid. There's no outstanding salary.
That is the crux of why we are coming to say that.
Yes, doctor, this is a claim for special damages, isn't it?
I agree. Yes, my lord.
Even on admission of the claimants, it still has to be, specifically pleaded and strictly proved. Even on
I agree, my lord. I agree, my lord.
So the claimant has come up with some computation that he, made on his own. Without the input of the defendant, and without showing any document how the computations were arrived at.
My lord, if my lord sees paragraph 7 and 8
of what?
Of our amended statement of facts.
Yes,
we said that from December 2010, that was when the issue arose. Yes. So before then, there was no problem.
Yes.
So from that time, they decided to pay entirely in naira.
In naira, yes.
We don't have any problem with paying in naira. The problem we have is that what conversion rate are you doing? Because our salary is denominated in dollars. Even if you didn't increase it, our salary is denominated in dollars. The exchange rate you were using from the beginning, from 2006 up to 2010, you are still using that same exchange rate.
Yes, but the thing is that if you are saying that when the defendant started paying the claimant in naira, how much was that naira that was paid to the claimant? How much was the difference? Is there any document that is showing this is what the defendant paid me in terms of naira, and this is what I'm supposed to be paid?
That is the computation that we have done in paragraph 8.
What I'm saying that not the computation made by the claimant. Like now, okay, you said from 2006 to 2010 there was no problem. That's so?
Yes, no problem.
There was no problem.
No problem.
Between 2006 to 2010, there was no problem.
To November 2010, there was no problem.
Yes.
And we agree.
Yes. The problem started from December 2010.
That's right.
Then from that December 2010 to 2019, is there any document showing this is how much naira the defendant paid to the claimant? And this is how much I'm supposed to be paid. Not the computation made by the claimant. Okay, for instance, the settlement of account of the claimant from 2010 to 2019 is not before the court, isn't it?
Yes, it's not before the court.
It's not before the court. And it's from that settlement of account between 2010 to 2019 that the court will look at and say, yes, from December 2010, the claimant was paid, say, 500,000 naira, which is equivalent to, say, 1,000 USD. So, and that statement is not before the court, for the court to say, yes, the claimant.
My lords, what the claimant, number one, it's not possible to sit down with the defendant to reconcile any accounts.
But it is possible for him to present before the court his statement of account from 2010 to 2019.
Because at that point in time, there were conflicts about whatever was being paid in.
Yeah.
Which didn't rhyme.
No,
what the claimant did,
for the court consumption, because between 2006 and 2010, you brought a statement of account.
Yes,
then why wouldn't the claimant bring the statement of account between 2010 and 2019? When there was a problem.
Because at that point in time, my lord, maybe it's not a question of address, but at that point in time, there had started to be misunderstanding, as can be seen by the correspondence between the parties.
Mr. Doctor, all what I'm saying is that since there was a problem from December 2010 to 2019.
That's correct, madam.
With regards to the defendant was paying the claimant in naira from December 2010 to 2019.
Yes, madam.
And when they are paying in naira, they were paying what they are not supposed. What they were okay. They were. I mean, the claimant was underpaid.
Yes,
because they were using the lesser exchange rate, wasn't it?
Yes, my lord. Yes.
So where is that document showing that this is what the claimant was paid in naira? That's just what I'm saying.
we don't have that that shows this is because if my lord sees the computation by the claimant, we'll see the progression from 150 naira to $1. The rate, for instance, in 2016, it became 196 naira to $1 rather than 150 that was being used.
Yes.
So if we make progress there, even as at 2018, 150, it became 306.
Yeah, doctor, that's not the issue I'm trying to raise.
Because we are using this as the last salary that he got, even if there was no increase.
But how was he paid, doctor? How was the claimant paid?
He was paid through an account, I agree.
An account? Where is that account? It is only that account will show that, okay, supposing in 20, the last one was January, February 2019. You said the exchange rate was 306. The rate used by the defendant to pay was 150 USD.
Yes, my lord.
Yes. The correct equivalent was 3,100,000 and something. The difference is 1,500,000 and something.
Yes.
The interest, how was the interest arrived at? We don't know. Then the difference is 1,600,000 and something. What I'm saying is that, where is the document showing that this is what the claimant was paid? Okay, supposing the claimant was paid by the defendant in accordance with the current rate then, that is 306. 306 instead of the 150 you are claiming.
No, then there won't be any disputes. It's because
okay.
We're not paid at that current rate.
Where is that document showing that?
And that is the emails that were exchanged to show that.
In the emails, email is a correspondence. They even denied it in the emails.
The emails.
It is a correspondence. It is a demand from the claimant to the defendant, and they even denied it. But what I'm saying is that from that 2010 to 2019, where is that statement of account of the claimant that is going to show how much the claimant was paid in Naira? Because it's only that statement that will prove to us that the defendant used 150, that's the old rate, instead of 306 as of 2019. It is only that statement. It is only that statement that will prove that. It is only that statement that will prove that.
I understand, my lord, sir.
Yes,
I understand that. The only thing that I wish to say is that if my lord looks at the correspondence, the emails exchanged, we'll know that a dispute had arisen.
Yeah, that was a dispute. But the defendant denied it. Okay, what will we say about the statement of the defendant, Mr. CJ, or what, saying that all the claimant's salary has been paid? That's not outstanding.
But because if my lord looks at that same email, it says the company has not increased salary for 8 years.
It says what?
The company, that is from the claimant.
From the claimant.
Yes, but there's something that J. Hodgson said here.
What did he say?
On that same email we're looking at, number 4, the company has not increased salary for 8 years.
Yes.
That would presuppose that it's the same salary that was being paid.
No, the thing is that was the claim of the claimant.
Yes.
It was because what do we say about the defendant's statement that, hi, Kenneth, you have been paid all your salary to date. That's not outstanding. That's not outstanding. It is a statement made by the defendant that the court has to make a finding on.
Yes.
That denial,
Yes.
how will the claimant rebut that denial? You know, if I say to my employee that I've not been paid my salary, and he denies it, he says that no, you've been paid all your salary. How will I? It means now the burden is now on me, being a special damage, or I mean damages to prove that I've not been paid. I've not been, because it is a special damages.
My lord, the way we look at it is that I understand the position of my lord.
Yes.
We don't have a statement of account that will show from that period. I concede that point.
And there's also no any document showing how we arrive at the interest.
Well, the interest is something that even if the court discontinues the interest, there's a
that can be implied. That it can be implied.
No, the reason why I'm saying that is that the question of interest follows the fact that money has been withheld.
Yes, but it's not in all cases. What the courts are saying in respect to prejudgment interest is that there has to be an express agreement. An express agreement that when one is owing another, it has to be in that agreement that in the event of default, the interest will accrue. It can't just be assumed. It can't just be assumed.
The reason why
because this is a pre-judgment. It's not a post-judgment interest.
Yes.
So, in respect of pre-judgment interest, there either has to be an express agreement between the parties that in the event of default, interest will accrue. Number two, or there has to be an express provision of the law saying that, okay, for instance, like in the Pension Act, there's an express provision saying that if there is any default from the employer with regards to the payment of pension, interest will accrue. That is the law. So it means it can be awarded even without the asking. But in this case, can the claimant just assume that, because the defendant refused to pay me my salary from so time, interest will automatically accrue? I don't think so.
I understand the position of my lord, sir.
Yes.
The way we looked at it is that if,
Yes.
for instance, we told, it is not only in commercial agreements or contracts that you award interest because you are withholding funds, monies that is due to the other party. We are looking at a situation where if he had the salary difference at that time, there's something he would have done with it.
Yes, but
usually there's no employer that will give will enter an agreement and say, I will pay you interest for.
The only thing one can claim is general damages. To say that I have suffered as a result of non-payment of my salary. But with regards to interest, which is a special damages, you can't just say this is what I'm supposed to be paid as my interest. But you can you can have other remedies, damages, general damages. Say as a result of the non-payment of my salary, I've suffered I've suffered that. But to say, because my employer, has refused to pay me 100,000 naira for 10 years, and I will not be entitled to 120,000 naira every month, that it will attract 20% interest. You can't just assume that. It has to either be expressly provided by law or by the agreement.
But I know that in course of trades, you can also infer that interest will be awarded.
Okay.
But I understand the position of my lord, sir, on this matter.
Okay. So maybe we are going to come back tomorrow for the judgment. Do you? I think there's no need for any readoption, ba? Haja?
Yeah, your lesson is already readopting, my lord.
Do you need to readopt?
Yes, my lord, because the stipulated 90 days has expired.
Okay, doctor. So maybe.
Maybe my lord, maybe the record will just show that there was. Is it reopening the matter?
Yes. What we have has just transpired now. I've recorded it. The question that I've asked you, I said that court is case adjourned to today for judgment, but there are some questions that I need. That some things I need to be clear about. Court to Dr. Nasir, is there any statement of account of the claimant between 2010 to 2019? And you say there is none from 2010 to 2019. And it's from that time that the problem started. I also asked how you arrive at the interest. And you said the interest can be inferred, isn't it? It can be inferred, even though there's no express agreement. So, doctor, tomorrow by 2, is it okay?
By 2 p.m.
Yes. Oh, yeah. Also participating in election petition matters.
No, my lord. No. My lord, the 2 p.m. is fine since it's later in the day.
Okay, it's okay. Okay.
Thank you, my lord.
If you want us to adjust it, we can say 3.
Okay, because I have a fixture for early in the morning. I don't know how late it will be, but 3 will be fine. 3 will be fine.
Okay. Haja is 3, okay. Haja.
I'm always in the court anytime. Anytime is okay by me. It's just that I don't know if I will have data for tomorrow.
I still coming to the court.
I'm coming. I've been coming every day.
Okay. In spite of the fuel increase,
my lord, we have even increased the money we are contributing to buy fuel for the staff bus.
It's okay. So cases are
not increasing, no.
God will help us, inshallah. It will be well with us. So cases are adjourned to tomorrow, 26th of July 2022 at 3 p.m. for judgment via
2023, my lord.
Okay, 2023, sorry. Via Zoom.
I was just, thank you, my lord. I was just saying that the record to show that since we're out of time, we reopened for further addresses.
Yes, I said that you wish to humbly readopt your final return address, which is dated 29/4/2023, but file on the 4th May 2022.
Yes, 29th April.
Yes, but file
That's
on
the
file on
final
the-
address, 29th
Yes.
April 2022. Yes.
but file on the 4th of May.
Yeah, filed on the 4th of May. Yes,
4th.
yes, my lord. Filed on the 4th of May.
Yes, I've recorded that. Okay.
Thank you, my lord.
Thank you, Doctor. I wish you all the best. So we see you tomorrow, God willing.
Thank you, my lord. Thank you. All right then.
Okay.
Tomorrow.
Haja, how are you?
Yes, sir. Okay, fine, sir. Okay, see you tomorrow, sir.
Thank you.
Tomorrow.
Bye-bye.
Bye-bye.
Okay. Okay, bye-bye. Thank you.